This is the third of a four-part series on alternatives to trial, or otherwise known as ADR, in divorce situations, and not necessarily divorce only, but other types of family law matters. This time, our presentation, the lecture now, is on the alternative dispute resolution in the form of med-arb. So what, obviously has been done, mediation. Sorry, I am a meditator, so I knew was going to come out of my mouth at least once in this series. Mediation. So we've already covered mediation and arbitration in separate videos, but med-arb is a combination of mediation and arbitration. This next slide talks about it a little bit more. So it offers some advantages of both mediation and arbitration, and it starts with negotiation and ends with a binding decision if one is needed. The flow is the parties first try resolving the dispute through mediation. Any unresolved issues in mediation move to binding arbitration or a private judge. It used to be used mainly in commercial law, and there's a lot in construction law in it too. Med-arb now is effective in family law and does still offer flexibility and efficiency in resolving disputes. Okay, next slide. So it's a two-step resolution process, as already indicated, and they collaborate in collaborative mediation is where it begins. And they work together to resolve disputes collaboratively with the help of a neutral facilitator. And then there's direct arbitration. So if, and in those issues where mediation fails, the unresolved issues go immediately through arbitration or trial. And that ends up in the impartial judgment and finality of the case. The role of neutrals, the process may use one or two neutrals, enhancing the fairness and increasing the chances of settlement. In family law, it's not used a lot in this area, but the benefits of it are it offers some finality. That's the big one. It's efficient, there's cost savings, and can help reduce family conflict. There aren't a lot of legal precedents in this area because it's just coming up as being something useful in family law. So there are some boundaries that just can't be defined. The optimal case for med-arb would be addressing unresolved collateral issues, and it's great for cases where there's some side issues that can't be settled through mediation or negotiation, and then getting a resolution because of that second phase of arbitration. It's efficient and swift and compared to trial and litigation in general, and so they can avoid some time in court. The cost and time effectiveness is also part of those two equations above. If we're looking for a marriage dissolution, post-judgment disputes, we've talked about how the family is unique and can the story continues to play out throughout the lives of people in family law. The job responsibilities of a paralegal in that case is going to be just like we've seen already in the mediation and arbitration slideshows. So I won't go into that, but these are the references for this particular lecture. Thank you.